you get any judgment on that case?
I don't have anything. I can go double check the email if you want.
She said that. She said somebody would drop it off for her.
All right, let me go check the file. There wasn't anything in the file on my desk.
Okay.
Let me see if someone maybe just emailed it.
Okay, thank you.
Yep.
Your Honor, this is Stephanie Halliday. I've been sitting in the waiting room.
Okay. Yeah, I'm sorry. It just said, are you still there?
Yes, I am.
Okay. It just said Google Pixel 8 Pro, so I wasn't sure who that was.
Yeah, sorry. I don't know how it shows up on your end. Sorry, I've been here since 1:30, so.
Okay, so we'll call Halliday versus Halliday. This is file number 25122020. The record should reflect Ms. Halliday is present. Turn on your camera. Also, I can't hear you, but the video is not coming through.
Yeah, I'm trying to figure it out. I'm on my phone, so.
Okay. If you can't, that's fine. The audio is coming through really well.
Okay, I think I've got it.
There we go. Yep. Okay, perfect. All right. So, Ms. Halliday, I have this set today for entry of judgment of divorce. Is that how you wanted to proceed? Can you just leave your phone unmuted? It keeps muting for some reason. There we go.
Okay.
Is that how you wanted to proceed today?
Yes, sir.
Okay. So Ms. Halliday, I'm going to place you under oath, and then I've got some questions I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Halliday, you filed a complaint for divorce in this case, and you signed that complaint. Is that true?
Yes, sir.
At the time, excuse me, at the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Crawford County for at least 10 days?
Yes, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Are you currently pregnant?
No, sir.
Under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
I understand.
And the judgment indicates that you and Mr. Halliday have already divided up any assets or debts of the marriage and that you don't own any real property or real estate together. Is that true?
Yes, sir. That's true.
Are you asking to have your last name changed?
Yes, sir, if I can.
Okay, what would you like that changed to?
Back to my maiden name, Kinkle, Kinkle.
K-I-N-K-L-E. All right. Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of the plaintiff. Mr. Halliday was provided notice of the date and time of today's hearing. He was defaulted back at the end of December. This was set for 1:30. It's now 1:53. He has not appeared. So the court will grant the divorce, and I've signed that judgment. Ms. Halliday, so that means your divorce is final as of today. Also, because the divorce is final, your name will be legally changed from this day forward. So you'll want to get a copy of the judgment so that you can change your identification and other documents. Did you have any questions at all?
I do not.
Okay. Thank you. That's all for this hearing today, and you're free to disconnect at this time.
Thank you, sir.
That's why I always bring 3.
Yes.
Okay. That's yours.
Oh, I can use this one.
Yeah.
All right, Ms. Chrisbell, are you ready to proceed on your case?
We are ready to proceed, Your Honor. My client is seated next to my left.
Okay, and
Yes,
Ms. Crook,
I am ready to proceed, yes.
okay, is your lawyer there, Ms. Crook?
He's in another courtroom, but he's on Zoom. Or supposed to be.
Okay, can you let the person there know? I don't see Mr. Thompson.
She's checking.
Okay,
He's in Judge Burmeister's courtroom right now.
all right, 1 second, counsel, we're just checking on Mr. Thompson's status right now.
Just for the purposes of housekeeping, basically, my assistant just emailed the signature page with my client's signature on the consent judgment to the court.
Okay. Yep, and I have that. So we have Mr. Thompson now, so we'll go on the record in Crook versus Crook, file number 2411820. We We have both counsel present. Mr. Thompson's here in person in the courtroom. Ms. Crispell is present by video. Both clients are present by video. And Ms. Crispell, were we ready to proceed with testimony and entry of a judgment today?
Yes, we are.
All right. Mr. Crook, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Ms. Crispell, if you'd like to proceed with the proofs with your client.
Thank you. Can you state your name for the court?
Robert Thomas Crook.
And are you currently married to Judith Crook?
Yeah,
And you filed a complaint in this case on December 11th of 2024, correct?
yes,
And when you filed your complaint, had you been a resident of the state of Michigan for at least 180 days before?
yes,
And when you filed your complaint, had you been a resident of the county of Crawford for at least 10 days before?
yes,
When you filed your complaint, you alleged that there was a breakdown of the marital relationship to the extent that the bonds of matrimony have been destroyed and there's no reasonable likelihood the marriage could be preserved. Is that true today?
yes.
And you, to your knowledge, is Judith currently pregnant?
Not that I know of, no.
And you've entered into a consent judgment of divorce, correct?
Yes,
You signed that consent judgment, correct?
yes,
And you are in agreement with that, the terms of that consent judgment, correct?
yes,
And in that consent judgment, you understand that you and Judith are both waiving alimony or spousal support now and in the future. And you understand that neither you nor Judith can come back to the court and request alimony in the future.
yes,
And you understand there cannot be a modification in that respect.
yes,
Now, have you consulted with me during this divorce process?
yes,
And you're satisfied with my services as your attorney?
yes.
I don't have any further questions, Your Honor.
Mr. Thompson, any questions for Mr. Crook?
This is less a question for Mr. Crook, but just so we're all on the same page, I believe the consent judgment does call for alimony to be paid upfront. It's factored into the property settlement. And I believe that there's a specific amount of, I think it's 48,000 addressed in the judgment. So I just didn't want there to be confusion. I agree there's no alimony moving forward because that's essentially taken care of in the property settlement today, but I wanted that to be clear.
Yeah, so I guess to both counsel, I kind of view that as part of the property settlement, like alimony or spousal support and gross, as opposed to what we traditionally consider as award of periodic payments of spousal support. So Ms. Crispell, does that accurately reflect the agreement of the parties?
It does accurately reflect their agreement, Your Honor.
Okay, Mr. Thompson, did you have any other questions for Mr. Crook?
I didn't have any other questions for Mr. Crook, Your Honor. Thank you for that clarification.
Okay, did you wish to take any testimony from your client?
No, I don't believe that's necessary.
Okay, Ms. Crispell, did you wish to take any testimony from Ms. Crook?
I don't believe that that's necessary unless Mr. Thompson wants to indicate on the record the restoration of his client's name.
That's spelled out in the judgment, so I think we're okay with that. Okay. All right, so the court finds that the statutory grounds for divorce have been met by the testimony of Mr. Crook. The court has reviewed the proposed judgment, finds that it's generally equitable and contains all the provisions required by statute. The court will grant the divorce, and I'm signing the judgment with today's date. Ms. Crispell, anything else that we need to address for the record today?
Just indicating that I understand that Mrs. Crook is going to be dropping a check off to my office this afternoon.
I would agree that's the plan, and I'd agree Ms. Crook is planning, once she drops off that check, on receiving a deed and a title to a vehicle. And I think that will complete the property settlement transactions.
Yes, it will. Thank you.
Okay, all right, thank you. Everybody's free to disconnect on this file.
Thank you, Your Honor.
All right, thank you. Adam.
Thank you. I'll be off the record. Okay, we're on the record in People versus Matthew and which is file number 255454 and People versus Baumgart, which is file number 25545. Have counsel put your appearances on.
Sorry, Sierra Coke on behalf of the people.
James Dick on behalf of defendant Matthew, Your Honor.
Walter White on behalf of Lawrence Baumgart.
Your Honor, as a preliminary matter, I'd like to make a motion.
Okay.
Your Honor, I'd like to make a motion for me to consider here the motion that was.
Wait, can you say that again? I didn't hear.
Oral motion for leave to file the instant motion. This motion was actually filed one day late. I want to bring that to the court's attention. I'm sure it's already aware.
The motion to quash.
Yes.
Okay.
I miscalculated the dates. It was my professional error, and I just want the court to be aware of that. However, with that, Your Honor, I would ask that the court looks at the overall circumstances, that whether like prejudice is the people here. With that one day late, it was approximately 24 hours. It wasn't a week late, or it wasn't the day before the motion hearing. It would be better to hear the argument from the marriage rather than just a default in this matter. Ms. Cope was also had also already prepared the motion for essentially the same argument for the co-defendant's motion to quash the matter. And with that, Your Honor, the court does have the discretion to accept court rules of MCF 2141. And I would ask I'm going to ask the court if you would do that.
Ms. Coke.
Your Honor, let's just proceed with a motion. I file the response.
All right, so the court will excuse the late filing issue and will proceed today on both motions on the merits. So both parties have filed motions to quash. I did have an opportunity to review both the written motions, the transcript from the preliminary examination, Ms. Coke, your responses. And so, Mr. White, I believe you're supposed to file first. Is there anything you want to state by way of oral argument here today?
Again, Your Honor.
Anything you wanted to state by way of oral argument here in support of your motion today?
Yes, briefly, Your Honor.
Okay.
Yeah, I'm like usually when a lawyer says briefly, I'm not lying. On page 843. No. Obviously, Your Honor, we've got a situation where the charge is assault with a dangerous weapon against my client. There's also a misdemeanor charge that runs along with it that we're not addressing today. The standard for quashing an information is abuse of the discretion on the magistrate. We are limited to the four walls of the transcript in order to argue our motion. And I would, pardon me, I believe that I presented our position fairly thoroughly in terms of what my client is accused of having done, and the fact that the behavior of my client has does not fall within the definitions or the jury instructions of assault with a dangerous weapon. And it's our position that the abuse of discretion was because the bind over did not reflect the requirements of assault with a dangerous weapon. So I'm not saying it didn't reflect possibly some other crime, maybe a destruction of property, but we've got a specific intent crime here. We've got behavior that my client is alleged to have struck the outside of a tow truck with a stick, and that is the limit of his behavior. I don't think it rises to the level of an intentional assault with a dangerous weapon. And I would just ask Your Honor to refer to the transcript as you said you have, and take a look at also the statute and standard jury instructions for what a dangerous weapon is and what is required to convict of this crime. Thank you.
Thank you. Mr. Dick? Yeah.
Yes, Your Honor. Just to caveat here, the required apprehension is an immediate battery, not just a generalized fear. Here, Mr. Ennis's person, he was inside the vehicle. The vehicle was not damaged in any manner. The vehicle was not something closely connected to him in this standard sense, whereas like something in somebody's hand or clothing would be impacted or closely connected to that person. And if, for instance, somebody grabbed somebody by the shirt, they could grab them, throw them down, or yank them, or jerk them, or perhaps strike them. Here, this is a vehicle that he's in the closed cabin that's structurally sound. Mr. Ennis did say multiple times during the preliminary exam that his window was up and whatnot. There was one single strike to some area of the vehicle with the quoting tire thumper and allegedly a mirror touch. However, Mr. Ennis did say on page 10 of the preliminary exam transcript, 9:21 to 22, he said he didn't recall if it was him or his truck hit his driver's side. That being said, Your Honor, of course, as the court's well aware, the truck, if used in a weapon-like manner, could be absolutely construed as a weapon. Here, the argument is that it was more generalized blocking and trying to stop the vehicle, where that was more likely characterized and should have been characterized as like careless and negligent, whereas ultimately something could have potentially happened. However, again, just to readdress Mr. White's point of the required intent, preliminary exam, while the burden is extremely low, it requires some condition of intent to satisfy that. We would argue that it's not present at the preliminary examination. Question.
Ms. Coe?
Your Honor, it's hard for me to understand how we can be sitting here today, even hearing arguments that this behavior wasn't intentional or it was not, does not meet the elements of specific intent. Not only did both of the defendants be present during the hitting of the vehicle with the large object that was either a stick or a bat, but they also both at different times during this cat and mouse game that they played with this guy who was just trying to do his job. They don't know him at all. They try to hit him with their cars, which in itself is a felonious assault. One of them actually did strike him with a car, and one of them he thought was going to hit him head on. There was multiple different assaults during this period of time, and how these men could act in this fashion and then say it's not specific is kind of absurd to me. They're standing next to each other, making him stop his vehicle while coming at him with a weapon, and then even after that, still continuing to chase him with their car, to the point that the police had to get involved and stop this chase. So this is clearly felonious assault. I think the jury trial will be very cut and dry, although I never want to say that about a jury, but the facts are very simple. And I think specific intent is so clearly shown that this motion is frivolous. Thank you.
Great. Again, I did review the transcripts, so I'm familiar with the testimony that was heard. I was not provided with the video as part of the motion, so I didn't review the video, but it's clear from the transcript that the district court judge did do that as part of the preliminary. So first of all, just looking at the standard here, the district judge is making the bind over decision based on probable cause. That is probable cause to believe that the crime charge occurred, each of the defendants were the ones who committed those crimes. And that's a very low standard, as the attorneys are aware. My review of that decision is even more deferential. The court's review is an abuse of discretion standard. And so in order to quash the bind over in either case, the court would have to find that the district court judge's decision was outside the range of reasonable principled outcomes. The law recognizes that in any decision by a court, that there may be any number of decisions which are correct under any given set of facts. And as long as the district judge's decision is within the range of reasonable and principled outcomes, then I'm not to substitute my own judgment, not to conduct a de novo review of the facts. Again, my review is simply of the district court's decisions. In this case, having reviewed the transcript, it's clear that, number one, the district court based the bind over decision on evidence and testimony, pointed to the specific portions of testimony and video that he felt justified probable cause. So it's clear to me that the district judge's bind over decision was arbitrary, capricious, that it flowed from the actual evidence that was heard in the case. Again, I'm not to conduct a de novo review, but having looked at the evidence, number one, I think it's clear that the district judge didn't look at this in a vacuum. Somebody standing there holding a bat or a slab of wood or a thumper, I think it was referred to, tire thumper, in and of itself may not be threatening or assaultive. Contact between two vehicles in and of itself may not be assaultive. But you have to look at the context and overall circumstances. You've got a gentleman here who's repossessing a car, who encounters one individual and then another individual who are, from the perspective of Mr. Ennis, clearly upset and angry that he's repossessing the vehicle. Clearly engaged in a course of conduct to try and thwart that, to stop Mr. Ennis from driving away multiple times over, I think he said a 10 or 15 mile or minute, I can't remember if it's mile or minute, but over an appreciable amount of time engaging in conduct, which I think any person would find threatening, certainly a reasonable person who's repossessing a vehicle encounters two individuals acting the way these individuals were acting would be reasonably fearful. And then when those individuals take those actions to the other level, not just trying to get in the way of the vehicle, but actively trying to stop them approaching the vehicle with an object, which, again, the description, I think a reasonable person would be fearful or apprehend a serious battery from an object like that. Certainly striking of the vehicle, again, not in a vacuum, but under these circumstances as they were being presented to Mr. Ennis, he and any other reasonable person under those circumstances would apprehend a serious battery, and certainly a vehicle is a deadly weapon. I think the way that the wooden thumper or bat was described would arguably meet the definition of a dangerous weapon. And so for those reasons, I certainly can't find that the district court's finding probable cause as to both defendants in this case is outside the range of reasonable and principled outcomes. So the court finds that the motions to quash should both be denied on that basis. And I'll just ask both defense attorneys to prepare orders reflecting the ruling of the court, either with a stipulation as to form from Ms. Koch or under the 7-day rule.
I did provide blank orders in both of them in my responses.
You did? Okay,
Yep.
Then I don't need the defense. I'll simply sign it. So thank you for representing. And then that takes us to the other matters we have set. Final status conferences. This case is set to go to trial next week, February 11th. I believe we have it set for 2 days. Is that correct? 2-day jury trial. So today would be the plea cutoff. Mr. White, have you had a chance to discuss with your client the plea cutoff?
We have discussed it. I haven't uh, we had an offer from the people and we don't feel we can take it. I mean, without going into the details of it, there's a medical reason why we can't take it. It doesn't relate to the reckless driving. I'll just tell you, my client is in treatment for cancer. The hard 2 month suspension of his driving privileges would be something he couldn't do because he's got to go to medical appointments all over. So.
Okay, so he's
So-
not gonna accept the offer.
No, we can't accept anything that didn't have that kind of driver's license consequences. May I ask the court a question?
Sure.
I have not tried a case in your county. Do you conduct voir dire or do you allow the attorneys to conduct voir dire?
I conduct some basic voir dire, but I do allow the attorneys to conduct some voir dire as well. I will say, I don't know, Mr. Dick, I've tried a case here yet.
Not before you.
Ms. Coke certainly has, she can, I'm sure, testify to the fact that I do and will limit attorney voir dire if I feel the counsel's trying to try their case in voir dire. In my view, the purpose of voir dire is to find out if there is any basis for a challenge to the cause and to allow counsel to get enough information to reasonably exercise their peremptories. To the extent it goes outside of those bounds, attorneys frequently, in my view, do try their case in front of the entire veneer. I certainly will stop that. So outside of that, I do allow some voir dire.
Do you require proposed jury instructions or for your questions by a certain date?
Yeah, so we did send out a pretrial order which spells that out, but I can tell you typically, I think
I think ours are done, but I don't know if we went ahead and filed them. I plan to have them done by today.
So I asked all counsel to provide the jury instructions electronically in Word format so that I can edit them, throughout the trial and prepare the final instructions. I don't need defense counsel to submit full text instructions. I just need you to submit any objections you have to the prosecutor's proposed instructions or any different or additional instructions that you are requesting. So I get usually I get all the basic ones from the prosecutor, and I just need defense counsel to just add things you want that aren't in there, or if you have specific objections.
Or present those electronically?
Yes. In Word format.
I did file a full text version.
And that's fine. Yeah, but if you can also send my office. Okay, so we'll plan on Mr. Baumgart is not going to accept the plea agreement. Mr. Dick, how about your client?
It was my understanding that his plea offer was revoked already, so we're still proceeding to trial.
Is that correct, Ms. Coe?
The offer stayed open till today, I think. Sorry if my notes are wrong. Maybe I'd said that, but I didn't write it down. Offer to Mr. Matthew was felonious assault dismissed habitual third. Offer to Mr. Baumgartner was assault and battery and reckless driving.
May I take two minutes to discuss that?
I have a procedural question. Are we going to have one jury?
Well, we'll address that.
Okay,
Yes. I would do that.
thank you.
We'll take a short recess. Okay, we're back on the record. So you have an opportunity to speak with your client.
I did, Your Honor, and we will be proceeding to trial.
Okay. All right, so, okay, thank you. All right, so, aside from the jury instructions, I'll just ask that, gentlemen, that you're here by 8:30 the morning of trial. Also, counsel, you can all be here and ready to go by 8:30 in the morning of trial. We'll start with jury selection, and then once we have a jury pick, we'll go right into openings and presentation of evidence. It's my intention to seat a single jury of 13 jurors so that's 12 with one alternate. Each side, each of the defendants will have 5 peremptories, and so Ms. Cope, that means you'll have 10 peremptories total. Does that answer your question?
It does. Yep.
Any other issues regarding trial? Ms. Cope?
No.
Mr. Dick?
No.
Mr. White? Any other?
None, Your Honor.
Okay. All right, so we'll see everybody on the morning of February 11th, and we'll proceed with both cases at that time. That's all we have for today. Thank you.
Thank you very much, Your Honor.
Sarah, can I see the 315?
I can mention it.
Oh, yeah. Okay, that's what now I know what you're saying. Got it.
All right, Mr. Carey, are you able to hear me okay?
Yes, Judge, thank you.
All right, I see Mr. Holsinger is signed in. Mr. Holsinger, if you want to be heard in this hearing, I'll need you to unmute and turn on your video, please. And Mr. Holsinger, I just need you to unmute. There should be an icon that looks like a microphone, like an old time microphone that has it. There you go. All right, thank you. Okay, we'll go on the record in Cadrano versus Holsinger. This is file number 2512025. We have Mr. Carey here on behalf of plaintiff. And we have Mr. Holsinger, who's the defendant, present here. We're on the record today for purposes of a default judgment. And so, Mr. Carey, I did receive your proposed judgment. Was there anything that you wanted to state in support of that?
No, I think the proposed judgment comports with the court rule on partitions. That's what this matter is a partition of a piece of real property. The real property is such that it's not subject to physical division. Accordingly, it doesn't need a partition commissioner to achieve that. What it does need to be is sold at market value and the proceeds divided equally. That was the allegations in our complaint. We perfected service over the defendant. The defendant did not file an answer, period, let alone timely. A default was filed against him. There was no motion to set aside the default. And here we are today asking for entry of a default judgment, which, I don't mean to make partition actions simpler than they perhaps are, but there can be no factual dispute that the parties are co-tenants. It's what the deed says. And there can be no factual dispute that either tenant in a co-tenancy in common is entitled to a forced sale of the property to realize their 50% undivided 1/2 interest. That's all we seek. The proposed judgment makes it clear that the cost of sale would be shared equally by the parties and therefore not in a manner that is unfairly prejudicial to the co-tenant, Mr. Holsinger, and I sure hope I pronounced that name correctly. So I'm moving for entry of judgment, and the court is, as indicated, has our proposed judgment before it.
All right, so Mr. Holsinger, it looks like based on the proof of service that you were served with the complaint for partition back on the 8th of December, and that you did not file an answer or otherwise defend. What's your position here today?
I did finally get a hold of a lawyer about it, and I sent Mr. Carey the form back filled out. I was just a couple of days. It was a couple of days before I got his form, but I did send him back some forms.
Okay. Well, it doesn't appear from the court file that you properly filed an answer in this case, and so you were defaulted at the beginning of January. So I guess, I mean, are you indicating that you're going to hire a lawyer to try and contest this?
I may, if I'm not allowed to get my principal, because I purchased the place.
Okay. All right. Well, I guess what I would say, Mr. Holsinger, number one, I think the default was properly entered, and I think a default judgment at this point is appropriate. If you wish to contest that, there are ways to do that, Mr. Holsinger. And so I would suggest that if you are going to contest it, that you get a hold of your attorney or an attorney as soon as possible and let them know the status of the case. And if you wish to challenge it, but at this point, I don't see any reason here on the record why the court should not enter a default judgment. So, Mr. Carey, the court will enter that judgment. Mr. Holsinger, that'll be served on you, so that's something that you'll want to take to your attorney if you decide to hire one as well. Otherwise, Mr. Carey, is there anything else that I can address for your side here today?
If the court was willing to, and Mr. Holsinger was obliging, I'd like him to state his current mailing address on the record so that there's no question that service of the default judgment is made at the address that he receives his important mail.
Mr. Holsinger, you have that? Oh, go ahead, sorry.
3382 East 800 North, Roanoke, Indiana, 46783.
Thank you, sir.
All right, Mr. Holsinger, did you have any questions at all?
No, not this time.
Okay. All right, thank you. That's all for this hearing today, and all parties on this file are free to disconnect.
Thank you, Judge. Thank you, Mr. Holsinger.
Yep, thank you.
Oh, yeah.
All right, we have everybody connected. We'll go on the record in Godiva versus Rutkamp and Elkhorn, file number 2411707. If I could have both counsel put your appearances on.
Good afternoon, Judge Elliott Blumberg on behalf of Brooke Godiva, who's appearing by Zoom from my office.
Good afternoon, Your Honor. Miranda Bailey Quick on behalf of James Rutkamp, who should also be on Zoom.
Okay, and I see Mr. Rutkamp is connected. We're on the record today for purposes of a status conference. What I'm looking for is a path to get a final order entered in this case. So obviously the parties have received the court's opinion and order on the underlying matter. Both sides filed motions which the court provided written responses to. So with all of that in mind, and I don't want to go over ground that's already been covered. I'd just like to see where things are at as we are here today, and what each counsel wants to request for scheduling to get this matter and a final order entered. So Mr. Blumberg, from your side on behalf of plaintiff.
Well, I can inform the court that the parties have tentatively reached an agreement on the disposition of the real estate in Crawford County. My client has executed a deed which we are holding and has signed a settlement agreement pending a walkthrough of the property, which Mr. Rutkamp apparently will not allow to take place. She has not been in that property for over 3 years now. She would like to be able to retrieve her personal property. We're not talking about furniture. We're talking about items that are specifically hers, and yet they won't allow that to happen. So that's where things are at, Judge, regrettably.
Okay, Ms. Bailey Quick.
Your Honor, yes, I agree that we have tentatively reached an agreement. I haven't seen that signed by the plaintiff. However, my client has declined a walkthrough. As Mr. Blumberg stated, Ms. Godiva has not been in the property for over 3 years. What he has suggested, and he's boxed up all of her personal property and belongings, and it would fill a large storage unit, Your Honor. I've proposed to Mr. Blumberg that my client would rent a storage unit, put it all there. He'd rent it for a month. She could retrieve it. And if there's something in particular, then she can let him know through counsel. But it frankly feels like it's an invasion of privacy of Mr. Rutkamp, who has already boxed up all of her stuff. So for her to come and do a walkthrough.
Judge, an invasion of whose privacy? They still own this property together until such time it's whether it's sold or conveyed to Mr. Rutkamp. She has every right, aside from your order, which excludes her from the property, excuse me, giving Mr. Rutkamp possession. All we're talking about is a 5-minute walkthrough. And frankly, this is just, again, more evidence of Mr. Rutkamp's lack of cooperation in this matter. What harm would be done? He doesn't even have to physically be in the place while she does the walkthrough. I'm astounded at the lack of cooperation.
All right, well, I guess here's what I would say then. It sounds like the parties have an agreement, which I think is a good thing. That's a positive step. I don't think it's unreasonable, given that Ms. Godiva hasn't had access to the property in a long time. And in light of the fact that she is a 50% owner of that property, that she should have some access in the nature of a walkthrough. Again, I mean, I've given the reasons why I don't think she should have possession at this point, and it's not necessarily on her. I think that's on both parties, and I've explained my reasons for that. But I don't think there's any reason why she shouldn't have some kind of reasonable access walkthrough of the property to make sure that that she can retrieve all of her personal items. I think that's reasonable. So I'm likely to order some type of access for Ms. Godiva if the parties can't agree on that. So what I would say is I'm going to give the parties 30 days to agree on some method, timing, and process for Ms. Godiva to have some access to that property, to go through it. Again, I think I agree with, I think both counsel, it doesn't need to be substantial. We're not talking about days or a week. I'm talking about somewhere in the nature of maybe 2 or 3 hours where she can have some access and see what's there and what's not there. And so that's what I would be envisioning. So I'm going to give the parties, again, 30 days to negotiate a process for that. To the extent that that doesn't occur, then Mr. Blumberg, I would ask that you file a motion to allow for that. I'll hear further arguments. Again, today's really a day for a status conference, so it's not appropriate for the court to make any rulings today. But Mr. Blumberg, then I would entertain a motion. And again, Ms. Bailey Quick, unless there's some reason other than what you said here on the record today, why Ms. Godiva shouldn't have some kind of limited access to that property, I'm most likely to order that. So I would encourage the parties to find some way to make that happen so that you can effectuate the agreement that has been made.
Well, Judge, if I'm sorry, I don't mean to interrupt. I apologize.
Yeah, go ahead.
Yeah, I know settlement proposals and negotiations are not generally within the purview of the court, but I think it's relevant that the proposal that we've accepted sort of expired by the time of the status conference today. I just want to make sure with the court's ruling that we still have an agreement, or is that off the table now?
Well, I'm saying what I'm saying, assuming that that is still an agreement by the parties. But I don't know. I guess Ms. Bailey Quick, can you speak to that?
That was the original intention, Your Honor, is that it be resolved as of the status conference today. You know, I understand what the court's saying, that she should be able to arguably do a walkthrough. It's my belief that it's probably to see if Miss Elkhorn is living there, which she's not. And so the fact is that all of her belongings is already packed up and isn't even at the property. And frankly, Your Honor, it's our position that despite the action before the court, personal property isn't part of that action. And we don't want to wait another 30 days to have either the court order this to be listed for sale or for the settlement to be agreed upon. If the court is saying that you're going to order a walkthrough, then I would ask at minimum that the stipulation and order be exchanged along with the settlement funds, and that put the real property issue to bed.
Yeah, so I don't really care what anybody's subjective reasons are for wanting to get to the property. If Ms. Godiva wants on the property because she wants to be satisfied that Ms. Alcorn's gone, you know, that's something that to me is completely irrelevant to the question of whether she should have some reasonable access, and I think she should. And so whatever her subjective reasons are for that, again, I think are completely irrelevant. I think it's a reasonable request, and so I'm likely to order that. So I guess Ms. Bailey Quick, your client needs to accept that, and if you can't figure out a way to make that happen, again, I'm happy to hear further argument. But if it's not something other than what we've heard today, again, my inclination would be to order that kind of access. So the parties can either drag it out longer, or they can just figure out a way to make that happen. And I'll leave that up to counsel and your clients. So I will put that into a status conference order today, and then we'll go forward from there. I do have a 3:15 and a courtroom full of people here that I need to get to, so I'm going to move on in the docket. Thank you, counsel. You're both free to disconnect.
Thanks.
Okay, the court will call, sir, can you tell me how you pronounce your last name?
Bourgeois.
Bourgeois, okay. I thought maybe that was it, but I didn't want to stab at that. Okay, Bourgeois versus Cooper. This is file number 251200022. Mr. Bourgeois, I'm just gonna have you sit over there.
Yes, thank you.
And then Ms. Cooper.
We probably need another chair. There's another chair.
How many, who do we have?
I'm sorry, Ben Gonick on behalf of Patricia Cooper with Cecilia Sarandongo representing her as well.
Okay. Yeah, you can.
Oh, thank you.
Video counsel, but I don't think I've ever seen
So
in person.
I was just telling them, I'm pretty sure I've been here before, and it's been a long time. Oh, no, not that long.
Oh, no, actually.
That may not have been caught for the record, so both counsel, if you can put your appearance.
Cecilia Carandongo on behalf of Ms. Cooper.
Ben Gonick on behalf of Ms. Cooper as well.
Okay, so we're on the record for a couple different matters here today. We have Ms. Cooper's motion to terminate the personal protection order that was entered in this case, and then we have a motion for. And then we have a show cause for an alleged violation of the personal protection order. And just for the record, the court received a request from law enforcement or a complaint from law enforcement for a violation of the order. And then Mr. Bourgeois followed that up with his own filing of a request for show cause. So I set both of them for the record here today. So typically the way I treat show causes, and I'd like to address that first, is I essentially treat it, counsel, as more or less an arraignment to advise the person accused of violating the personal protection order of their rights, the maximum potential penalties, and to determine whether or not that person wants to contest a violation or admit responsibility. If they want to contest the violation, then obviously they're entitled to a contested hearing, and I set that for a hearing date at which both sides would have the ability to present testimony and evidence, and then the court makes a ruling as to whether or not there was a violation. So it'd be my intention to go through that process with Ms. Cooper here today. Because I view a violation of a personal protection order as relevant to whether or not it should stay in place, I typically will conduct the proceedings on the violation and then schedule a hearing on the motion to terminate following a determination as to whether or not it was a violation. So that's my intention of proceeding. You have a question about that? Well, and I guess I'll say this too, and I do this in every case where there's multiple attorneys. I don't like to get double teamed. So I'll just ask I'll just ask one of you to be the representative for purposes.
Correct, and that's what we'll do.
Okay.
So, Your Honor, if we're just arraigning her, so she would be contesting the violation for the same reasons that she's contesting the issuance of the PPO.
Okay. All right. So, Ms. Cooper, I want to make sure, number one, that you are aware that you do have the right to have a hearing as to whether or not you violated a personal protection order in this case. Do you understand that?
Yes.
Okay. And you understand that if you are found guilty of violating the personal protection order, then you could be found in contempt and you could be subject to sanctions up to including 93 days in jail and or a $1,000 fine. Do you understand that?
Yes.
With that in mind, your counsel's indicating that you'd like to state that you're not guilty or that you didn't violate that personal protection order. Is that position?
Correct.
So the court will enter that on your behalf today, and we'll set this for a contested hearing. Counsel, how much time we would need for that hearing?
Well, I guess it depends what the other side is going to argue, but I wouldn't say more than an hour or an hour and a half or so, maybe.
Okay.
Probably just an hour. And I say that because I think it's very important for the court to have the backdrop for why it got to that point, you know, that then resulted in the violation being issued, if that makes sense. So I don't think the court can kind of hear it in a vacuum. So that was probably why you saw my puzzle, you know, face, because I was used to doing it the other way around.
Okay.
That a court does the motion to terminate first and then proceeds to the violation. I would just ask that we be allowed to, you know, present kind of backwards too, because I think it needs to be put in perspective for the court.
Yeah, I mean, within reason.
Correct.
I presided over an Open Meetings Act
Yes,
matter.
correct.
And so I'm sort of familiar with
Correct.
some of the things that have been going on.
That is correct.
So.
And I think that, you know, the latest instances, if you will, I'm not sure the court is familiar with those.
Right. Understood. Okay. Ms. Koch, how much time do you think you would need?
I think we can do it in an hour. I asked the clerk today if we were going to be handling this, if my office was going to be appointed to it, because I wasn't sure exactly what was on the docket. She indicated I was, so I am present. I reviewed it, and I don't think there's, it's going to be a lengthy hearing. So we can do it within the hour.
All right, so I'm going to set it for a 2-hour hearing, just to be safe, that that'll give us plenty of time. Ms. Koch, do you need any particular period of time to be ready to go forward on it?
No.
Counsel, do you need any particular period of time or just as soon as the court?
No, because I think we were ready to proceed today, so no, except I'm out of the country next week.
Okay.
To handle my mom's estate, so I'm not available next week.
Okay, so the court will set this for a 2-hour hearing. I'm in trial all next week, so at the court's next available date. Mr. Bourgeois, it's just important that you stay in touch with Ms. Koch so that you can help her prepare for your case. Do you have any questions about how we're going to proceed at all?
I think I understand it, Your Honor. Thank you. And I will be out of town on the 19th, 20th, 21st of February. So I don't think it's going to be that quick, but just so.
Okay, thank you.
Thank you.
All right, Ms. Koch, anything further from your side?
I don't know if the court can address this, but it may be pertinent to future issues, but the PPO that's in place, does the court feel that it limits Ms. Cooper from going to the location where Mr. Bourgeois' office is at the township building in the future so that we don't have any additional problems?
I mean, this is a sticky case, I think, as we all recognize, because Ms. Cooper has certain rights to be at hearings and to participate in those hearings, but those rights don't extend to the point that she's harassing or threatening or intimidating or engaging in prohibited conduct under the personal protection order statute.
And if I may, so the violation, you know, if we're talking about that, that was took place during a meeting. I don't think there's any allegations that Ms. Cooper has ever just shown up at random. She just attends these meetings. And my understanding from watching a year worth of meetings is that the fire chief comes and there's a written report and he reads it into the record. That's what he does. And then sometimes he makes comments as a member of the public, which oftentimes are directly at her. So I wanted to suggest that if there were issues with people, physically being present in the building, that somebody could accommodate someone, either the petitioner or Ms. Cooper on Zoom or Teams or something like that, if they were concerned about it. But she's never, from what I know, shown up, during outside of those meeting hours.
Yeah.
So it's not like she shows up and is banging on the man's door or anything like that, that I have no record of any of that.
Yeah, and I mean, I don't know, and that's where, the evidentiary part of this is gonna come in, where I'm gonna hear some testimony about what actually is happening, when, and what context. So.
Yes,
I do know that. I appreciate your representation, but at this point, I don't know. I haven't heard any testimony, I can't make any actual decisions about whether what Ms. Cooper is doing at any point during these meetings or after them. Is either protected or not, or prohibited under the PPO. So I think that's what we're going to need to get to. So I guess what I would say is, and I'm sure you've already done this, is to just caution your client that she needs to make really sure that what she's doing is going to be within the scope of what's protected and what's not. And obviously, if it turns out that she was engaging in what I find to be protected activity during the course of the public meeting, I won't be able to sustain the PPO violation. But if I don't, then I will. So,
correct.
Yeah, I think everybody's, needs to recognize that this is not going to be a black and white, real clear situation. So I think everybody needs to exercise caution in terms of.
And perhaps we can have discussions with Ms. Cole too.
I think that would be a great idea. And honestly, based on everything that I've heard, I think, counsel, exactly. So, sense. Go with each other in a civil manner, exercise their rights and exercise their duties as officials. Fair way that isn't purposely aggravated. Council is and we have a lot invested and we have a lot of history. That would be my hope. If we can do that before the next hearing, that's great. If not, then I'll take testimony and I'll. That's what I think.
Thank you.
Thank you.
Thank you.